If you employ people in the UK, there is one date you need to know about now. The 1st of January 2027, because from that date, one of the biggest changes to unfair dismissal law in over a decade comes into force. Now, before you panic, this isn't one of those videos where I'm going to tell you that every single employer is suddenly going to be sued. That's not my style. In fact, I think a lot of the headlines have been unnecessarily dramatic on this kind of stuff. It wouldn't be like them. But I do think that thousands of businesses are underestimating how much they are going to need to change the way that they recruit, the way that they manage, and the way that they dismiss employees because of this change. So today I want to explain what's actually changing, why it matters, and most importantly, what practical steps I'd be taking if I ran a business employing people, which I do. Let's start with the biggest misconception. At the moment, most employers know that they have a degree of flexibility during an employee's first 2 years. That doesn't mean that you can dismiss someone for discriminatory reasons or ignore existing legal protections. Those have always applied. But for ordinary unfair dismissal claims, the qualifying period has always been 2 years. From the 1st of January 2027, that qualifying period reduces dramatically down to 6 months. At the same time, the statutory cap on the compensatory award for ordinary unfair dismissal claims is due to be removed. There's no limit on what you can claim for now. Those two changes together are why employment lawyers have suddenly become very busy and will continue to do so. But here is the part that I think people seem to be getting wrong. I've seen lots of commentary suggesting that businesses will simply stop hiring. I really don't think that's what good businesses will do. Personally, I think that good businesses will become better employers. The businesses that are going to struggle aren't necessarily the ones with the largest workforce. They're the ones that rely on informal management. The businesses where probation reviews never really happen, when performance concerns aren't properly documented, it's all verbal, where managers avoid difficult conversations, where someone gets to month 8 or 9 before anyone says, actually, this isn't really working out. Under the current system, some employers have been able to rely on the fact that an employee hasn't reached 2 years service and get rid of them quite quickly. That safety net is now becoming much, much smaller because of this law change. So let's think about what that actually means in practice. Imagine you recruit someone today. They're enthusiastic, they interview well, and they start work. 3 months in, there are a few concerns. Nothing major, but they're not quite performing at the level that you'd expected them or need them to. In many businesses, that conversation gets delayed. Let's give it another month and see how they get on. They're still settling in. We'll review it after the summer. Always a reason. Before you know it, 6 months has passed really quite quickly. From 2027, that would put that business owner in a very different position. The businesses that manage this well will be the ones that identify concerns early, communicate them clearly, and make decisions promptly. That's why I think that probation periods are going to become much more important going forward. Not because probation suddenly becomes a legal shield or anything like that. It doesn't. That's not what the law does. But because it forces businesses to have structured conversations much earlier, which is probably a good thing. If I were advising a business today, one of the first questions I'd be asking is, when was the last time you reviewed your probation process? Is there actually a process in place? Who is responsible for that process? What happens after 1 month? What happens after 3 months, 5 months? Are managers trained to deal with this? Or does everyone simply hope that things will work out? The second thing I'd be looking at is recruitment, because one of the easiest ways to avoid employment disputes is to recruit the right people in the first place. Too many businesses recruit just because they're busy. They don't recruit because they are ready to hire. Then they spend months trying to manage somebody who was never quite the right fit in the first place. The new rules make that a much, much riskier strategy. The third area is management training. This is the one that I think is the most overlooked and potentially the most important. Most employment claims don't start because the law changed. You rarely hear that. They start because a manager didn't know how to have a difficult conversation, felt awkward about it and put it off. Or they avoided having one altogether. Or they assumed that HR would deal with it at some point. Managers need to understand how to set expectations, give feedback, document concerns in writing, and deal with these issues consistently. That is good management, regardless of what the law says or is about to say. Now let's talk about another headline you've probably seen. Unlimited compensation. Wow, that sounds absolutely terrifying. But it's important to understand what that actually means in practice. It does not mean that every unfair dismissal claim will suddenly be worth hundreds of thousands of pounds. Tribunals still assess compensation based on the employee's actual financial loss and the facts of the case. What it does mean is that the current statutory cap on the compensatory award is being removed, so it could increase the financial exposure in some cases, particularly for higher earners. For most SMEs, the bigger impact won't be the compensation itself, actually. It will be the time, the management, the distraction, and the legal costs that are involved in defending claims that might previously never have arisen. And that's why preparation really matters. So if I were sitting down with a business owner this afternoon, these are the 5 things that I would be telling them to do before January 2027. First off, review your recruitment process in full. Secondly, tighten up and properly document your probation procedures. Thirdly, train your managers. Fourthly, update your employment contracts and handbook if they no longer reflect how your business operates. And finally, don't wait until month 6 to decide whether someone is the right fit. Have regular, honest conversations from the outset. And one final point I'll leave you with. I don't actually think these changes are about making life harder for employers, although it can feel like it sometimes. I think they're about encouraging businesses to manage people more proactively and more effectively. The employers who already recruit carefully, communicate well, and deal with issues promptly are unlikely to have to reinvent the wheel here. The businesses that rely on "we'll deal with it later" are the ones that are absolutely going to feel the biggest impact. So yes, employment law is changing and we all need to be very aware of its consequences, but I think the real message here isn't to be afraid, it's to be prepared. Because the businesses that prepare now won't just reduce their legal risk, they'll probably become better employers as well and attract better staff. If you found this video useful, make sure you subscribe, because over the next few weeks I'll be breaking down the biggest employment law changes coming into force, and more importantly, what they actually mean for founders and growing business owners.